The Supreme Court held the second pre-hearing conference of the petition filed by former presidential candidate Amama Mbabazi challenging the re-election of President Yoweri Museveni. At the conference, the parties agreed on the issues to come up during the main hearing. The Attorney General's team, led by Deputy Attorney General Rukutana, was the first to make submissions. He went straight into the matter of the double break-in on Tuesday night at the offices of two law firms representing Amama Mbabazi. In his submission in court, the Deputy Attorney General Rukutana said that he will not be surprised that the break-ins into the offices of Mbabazi's lawyers were stage-managed in order to attract sympathy from court and the entire public. He also added that this could have been done in order for them to cover up and also buy more time.
Counsel for the petitioner should be prevailed upon to refrain from that unbecoming behavior or should be reprimanded by this honorable court not to engage in unprofessional conduct.
But Mbabazi's lawyers told court that they were shocked that the Deputy Attorney General could impute wrong motives on their part.
My Lord, it is therefore, in my view, very unfortunate for someone to state that this was stage managed by the petitioner and his legal team, because we have absolutely nothing to gain from such a process.
Rukutana also denied claims made by Mbabazi's team that over 20 of their witnesses were picked up from various places and first detained at the Police Special Investigations Unit in Chireka and later Nalufenya in Jinja. He said after investigations, it was established that no suspects were held at any of the mentioned police facilities.
Why the petitioner or his counsel should raise such a malicious and false allegations against the Uganda Police Force or the security agencies of this country?
We are grateful that the Attorney General exercised the greater presence of mind and responsibility when that matter was raised before this honorable court. If that is unprofessional, if it is discourteous, I leave it to court, because in any case, we are not asking for a ruling on that matter.
The petitioner's lawyers also came under fire for not submitting the amended affidavits to the second respondents to the Electoral Commission, yet they had agreed to submit them on 7th March.
This issue was raised to you, that the affidavits you are talking about in this petition had not been filed or served. And you undertook to file and write and serve them the same day by close of the day on Monday. Now that was before this break-in, this is before the people were arrested and so on. You are saying you had affidavits that were supposed to accompany this petition, and you undertook to serve them. Now the question is, where are these affidavits, and why have you not complied with the directive of court?
My Lord, if I recollect, I instructed one of our colleagues to serve that day. So I am surprised that they were not served on that day. But I did instruct one of my colleagues to serve them.
Look, Mr. Kampura, you undertook the court to file this document. This is a very important petition, isn't it?
It is, my Lord.
It's a very important petition, and you are a senior lawyer. You claim in your petition that these affidavits are accompanying your petition. So really, it's not an explanation to the court. You should in fact explain to your petitioner why you are messing up his petition.
The petitioners were given until end of business on Thursday to file all the supporting documents, which include affidavits from their witnesses. NTV has learned that the petitioners managed to beat the deadline. The Supreme Court will sit again on Saturday to hear the application of 8 civil society organizations and 9 Makerere law lecturers who are seeking to be enjoined in Mbabazi's petition as amicus curiae of Friends of the Court. Sudhir Yarhanga, NTV.